Canton Confidential, the Karen Reed murder trial, starts right now.
And a bizarre start to the day in the Norfolk County Superior Courthouse. Judge Beverly Cannoni calling for an immediate sidebar and a temporary ban on cameras in the courtroom. Thanks for joining us for Canton Confidential. I'm J.C. Monahan.
And I'm Glenn Jones. The situation led to a lot of confusion and plenty of questions. Ultimately, though, we now know one juror was dismissed. For those keeping count, that means there are now 15 jurors left.
Here's a look at the math. During jury selection, 19 people were selected. Before testimony began, 2 chose to drop out. That left us with 17. On Wednesday, 1 juror left for personal reasons, and then today, another one went home. So that leaves us with 15 jurors. And to clarify, that's 12 in the jury with 3 alternates.
All right, before we get into testimony, we want to kick things off tonight with Sue O'Connell, our courtroom insider and commentator. All right, Sue, when this happened this morning, I feel like half the state was losing its mind.
Yes.
But it was also confusing as people tried to explain what was happening in the courtroom because you couldn't see in the courtroom. So was it confusing in there as well?
Yes, it was, because we didn't know what was happening. And just to kind of set the stage, I mean, we live in such a free society that having to sit quietly for an hour and watch something happening.
Torturous.
And you don't know what's going on, and you're trying to guess, and everyone's just sitting. The jury wasn't in the room. But it lasted for about an hour, and about at 9:10, you know, the judge starting the day with a sidebar is not unique. That's been happening on a regular basis. But a juror was brought in, and she met with them for about, you know, a good 10, 15 minutes. What happened with the feed was that the camera person, the photographer, who's the pool photographer who was providing the video for everybody. We all agree that there's one still photographer, one video photographer who gives us all the feeds. He did not know that the juror was coming in because he was not alerted by the court.
And that's what usually happens.
If that's going to happen, then it goes on the fan or it goes somewhere else. And he just thought the court was starting and had a pan shot, and the juror walked in. As soon as he saw that it was a juror, he panned up, meaning he picked the camera up so he couldn't see. So that happened. That's a separate issue. The other issue was you had a number of jurors. You had 1, 2, 3, 4 that came in over this hour, some of them repeatedly. The juror who left came in 1, 2, 3, 4 times, met with the judge on a sidebar. Now it's clear that the judge was questioning the jurors, asking them for their opinion about what happened. We overheard Judge Cannoni say once or twice, did she say that to you directly? Did you overhear that? And obviously there was an issue with the juror who was dismissed. I don't know if it was personal. I don't know what it was. We don't know. We may never know. But in the end, after an hour of all of us sitting there quietly and the stress and the tension that was in the courtroom, because nobody wants a mistrial.
Well, I was going to ask, how was it with the attorneys?
Everybody was stressed. Everybody had concern on their face. Karen Reed, Reed supporters, the O'Keefe family. When the jurors started coming in, there was a worry that, oh my gosh, are all these jurors going home? Oh. Are we going to lose 4 jurors today? And where is that going to put us? And then are we going to be in mistrial? And so we didn't know what was happening. And we wouldn't know what was happening until after 10 o'clock when court started and the jury came in, and the juror who was sitting in the front row of 2 rows, right in the middle, she was gone. And then the court proceeded the day proceeded as it usually would.
You must have felt like crisis averted at that point.
Yeah, I mean, nobody wants a mistrial.
Yeah,
right.
Absolutely not. All right, let's go back to this point about cameras being turned off, because when that happened, people's hair did catch fire today. But we should remind people that the camera in the courtroom isn't absolute, right?
No, it's a privilege. Yes, first of all, it's a privilege for us to be in there. You can argue whether court TV should be in there or TV should be in there all the time. Federal cases aren't allowed, all that. That's a separate argument. But in this case, in this state, it's a privilege for us to be in there that is granted to us. And the photographer who was in charge of the camera is a seasoned vet and does this all the time. So I'm sure it wasn't a mistake that he made. It was a kind of a mistake that he wasn't miscommunication that happened. So,
but it then left all of us out.
Yes, yes. So we did get the Zoom info. We did try to get that out there. Everybody adjusted, and eventually we did get back on by about 11, all the platforms. But And the image of the juror was deleted and the video was deleted. So please don't watch it if you see it somewhere, and don't forward it, because that person deserves their privacy.
All right. Thank you for that explanation. Thank you.
All right. We do want to note, despite not having a live camera feed this morning, we did have live audio of the first witness, which is a good thing because the day was filled with important expert testimony for the prosecution.
The first witness called specializes in digital forensic. Jessica Hyde spoke to the Google search on Jen McCabe's cell phone. You've heard of it before. How's long to die in cold? Then this afternoon, Trooper Joseph Paul broke down specifics of the crime scene and the Commonwealth's theory of what happened to Boston police officer John O'Keefe on that cold January night. Our John Maroney is in Denham with the highlights.
Then at 6:24, we get the next search, which is HOF, long to die in cold.
An expert in digital forensics testifying about the Google search by Jennifer McCabe, How's long to die in the cold. The defense claims McCabe did the search at 2:27 in the morning because she and others knew John O'Keefe was lying in the snow.
I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
Last month, McCabe testified she searched much later in the morning and at Reed's request after they found O'Keefe. Digital expert Jessica Hyde says an open tab may be why the search seems to have taken place at 2:27.
It is a high likelihood that that tab was opened at this time because there was another search that occurred at 2:27 in the morning. It was a sports site.
Despite her conclusion, the defense pressed her on whether she could rule out the early morning search entirely.
There is no indication of a Google search at or before 2:27 a.m.
She's not saying it didn't happen at 2:27. As a matter of fact, Occam's razor suggests that's exactly when it happened.
Trooper Joe Paul examined Reed's vehicle and crime scene for state police, creating this map. He said O'Keefe's sneaker was located 9 feet from his body, a broken drinking glass a foot away. The prosecution claims the defendant backed into O'Keefe and hit him based on data from the SUV.
This vehicle is backing up in the manner of about 5 seconds or so in a fairly straight line and achieves a maximum speed of 24.2 miles per hour, correct?
Correct. Yeah, cars can go backward 24 miles an hour. That's not the point. He's misread almost every single bit of the data.
Trooper Paul will return to the stand Monday, and that's when the defense will have a chance to cross-examine him. In Dedham, for Canton Confidential, I'm John Maroney. Back to you.
Okay, as John reported, another day of expert testimony, which seemed to only generate more questions about the case for you at home. Principally, you want to know, has the Commonwealth presented enough proof for the jury to find Karen Reed guilty in her boyfriend's death?
We're talking about it when local attorney Morgietta Dourcier joins the conversation, and you can as well. We have been reading your questions and comments all day. If you have one for our experts, send us an email at canton.confidential@nbcuni.com. We'll be right back. Welcome back. With us tonight is local attorney Morgietta Dourcier. Morgietta, as always, thank you for being with us.
Thanks.
The prosecution started today with a digital forensic expert who really was, a lot of it was focused on the Google searches, because that was a big point that a lot of people talked about. At what time did she, Jennifer McCabe, search on her phone how long to die in the snow? Technically, how's long to die in the snow? Let's take a listen to a clip from testimony, and then we'll talk about it.
It is a search for the term HOF, long to die in cold, and that a timestamp in this instance is from the browser StateDB, which is right here. The browser StateDB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that that tab moved. That is what that timestamp is for. This search term is always going to be the most recent search term in that tab. That means the last item that was opened in that tab was HOF, long TI, die in cold. We cannot tell by this particular artifact what time that search occurred. It is a high likelihood that that tab was opened at this time because there was another search that occurred at 2:27 in the morning.
So basically, 2:27 in the morning, the tab is open and she searched a sporting site, and then she can't say exactly when, how's long TI to die in the snow is. Was she successful in pushing that across the finish line for the prosecution to make that point?
I think it's really hard to tell because then on cross-examination, I think the defense again did a good job of getting her to not actually point to that exact specific point, right? And so was that point achieved? I'm not really too sure because it was still a little bit confusing as to whether or not that was actually searched at 2:27 a.m. And that, again, is going to leave the jury a little bit confused on that point. But I'm sure the defense team is going to bring their own expert to counteract or bring in a difference of opinion. So I'm sure that's going to be coming in the coming weeks.
In fact, let's talk about that because we know from a pretrial affidavit that the defense team's expert is going to get up there and say that that search did happen at 2:27 a.m. And if now Yannetti has gotten this prosecution witness to agree that that is maybe possible, what is the jury left to do having these competing experts on the stand? Who do they believe?
Absolutely. I think it goes down to, they each give their credentials, how long they've been testifying, where they went to school, things of that nature. So the jury is going to use a part of that to make their analysis. But what's their credibility on the stand? How well did they respond? Were they engaging? Did their plausibility actually make sense? So I think the benefit for the defense team is they've already seen the prosecution's witness go first, right? So that particular person's going to take some notes and, perhaps make some adjustments that actually make sense. So we'll see when that person actually gets on the stand.
Well, it's a lot of data that was thrown around. And so even without the defense, if we take that out, which of course the jurors can't, but just a hypothetical, did they still land the point, though? If Alan Jackson had not had a chance to cross-examine, would you have been able to walk out today after this testimony and go, oh, okay, the browser was open at 2:27 a.m. and the last thing that was in that browser was how's long to die in the cold at 6, whatever it was, 27 in the morning.
Something like that,
right,
yeah.
Right. I think the point is that they missed the point a little bit, right? Because jury wants something complete and concrete, right? And I don't think that point was completely made, which is why I think the defense now has an opportunity to bring their expert in and maybe hone in on that particular point. And that's the last message that the jury is going to hear. So it could be a point for the defense team.
And for people who maybe haven't been following as closely as we have, it's important to point out that if this search happened at 2:27 before John O'Keefe's body was found, it has different implications than if it was found, if the search was made at around the time that his body was found.
Jennifer McCabe has already testified that that happened after Karen Reed called to say that John hadn't come home, that they had arrived at the house at Fairview Avenue and then Fairview Road, I should say, and that's when Karen said, Google how long to die in the cold. So that time is important to both sides of the case.
Absolutely. And if it happened at 2:27 a.m., it does lay credence to this third-party culprit defense.
Absolutely. And I think it also goes to credibility because there have been so many witnesses that have testified. The jury is starting to probably window down, all right, who are we going to start believing, who do we not believe? Right. And this evidence by these text experts is really going to help them pinpoint that.
Morgietta, don't go anywhere. We need more. She's sticking around. After the break, though, we'll be joined by our Sue O'Connell.
This afternoon, a car crash expert was called to the stand. When we come back, more on what we learned from his testimony.
Welcome back. With us again is local attorney Morgietta Dourcier, as well as our own Sue O'Connell back at the table. We want to start with the fact that we touched upon this already. Already there has been so much data in the last couple of days. This jury has listened to more than 60 witnesses, and now we're really getting into this nitty-gritty math and technical information. And in your experience, I'll start with you, Morgietta, can the jury really process all of this after listening for 7 weeks?
It's going to be really difficult, but like I said before the segment, it's about credibility. Who are they going to believe, right? The jury is going to come in with their own common sense. Some of them may have already formed an opinion or not, right? But I think the reality is that it is a lot of information. Hopefully they are taking notes, but I wouldn't be surprised if they're tired.
Sue, you're sitting there looking at the jury. Are they glazing over? Are you taking notes, or do you even feel like I'm putting it down?
Yeah, we talked earlier, my approach to stuff is sometimes I don't take notes. I just like to listen, and I think if I were a juror a few weeks in, I'd be like, oh my gosh, I should have been taking notes. I didn't do it. One of the juror who was dismissed today, she was a big note taker. She actually had 2 notebooks that they replenished, and she's off the jury now. We talked about the concern about just being able to process this data when you can't take your notebooks home with you, you're not supposed to be talking about the case, you're not supposed to be doing any investigation or web searches, and sometimes at the conclusion of testimony, all of us reporters and press get together and go, no, wait a minute, what did they say? Where did that go? What are we trying to figure out? And I just have great sympathy and concern for the jurors who, at the end of this, are going to have to take their notebooks, which they're not studying,
right,
and then go deliberate and try and map all this out. It just seems like a crazy way to run a railroad.
I take notes, but I have to flip through that book every day to go back and forth. So.
All right, today's second witness testified to some of the most specific evidence in this case. This is important because, of course, the Commonwealth says John O'Keefe died as a result of a car strike. This is a state police crash reconstructionist. Let's listen to this clip.
Based on your training experience in particular to pedestrian collisions, what, if any, significance did that have in relation to your opinion as to how Mr. O'Keefe interacted with the defendant's vehicle?
When you look at the damage, he would have interacted with that left side of the vehicle. And when he got struck by the vehicle on the left side, it would have caused his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn it into his back, and his back could have struck the ground. I noted at the scene that there was asphalt curbing, which could have, somewhere he could have struck his head in there, or somewhere along any of the pavement would have caused damage. Most forward projection crashes have damage on both sides of the body.
So based on what the Commonwealth is trying to prove here, it would seem to me the jury has to believe this witness a lot. He is so critical to the case. Did he deliver?
I think he made some really good key points about his analysis of the area, but they're going to have to back that up with another expert, which I hope is coming on in the next coming week, like a medical person, right?
I see.
So I think if they land both of those experts really, really well, they may have moved the needle a little bit. But again, they still have a lot of reasonable doubt that has been spread throughout this case that may not give credibility to what we just heard.
So can I ask you the same question a little differently? When you think about all those 60 witnesses that JC was talking about, have the witnesses who were eyewitnesses or the witnesses who are experts provided a better context to the jury?
Well, those are two very different categories, right? The expert witnesses, some of them are great at testimony, some of them are great at just the information that they're putting forward. The eyewitnesses, the folks that were at the scene, you have to kind of assess them differently because they're not professional testifiers. And some things that might not come across to the jury may not be because they're being evasive. They just might be afraid, or they might be nervous, or they don't know what the heck's going on here. So you've got these two categories of witnesses, and then when they go into to actually try and figure this out, they're going to have to match those stories. Like, did what Jen McCabe said and Carrie Roberts about where Karen Reed said she went, does that match the data that goes with the cell? And that's just on the prosecution side. So
it's interesting you should say that, because I'm thinking of Brian Higgins and Brian Albert, who actually could fit in either one of those categories. I mean, in this case, they are eyewitnesses, but they are people who testify at trials.
Right, and also how does the jury take that in, too, which is another thing. Like, sometimes when police officers or law enforcement get in to testify, sometimes, and I don't know that they did this, but sometimes they, and you'll speak better to this than me, but sometimes they get so caught up in making sure that they don't put themselves in a box, or they're testifying in a way that is just answering the question, it inhibits them, and sometimes the jury might read that as them not being genuine, right?
Before we go, we want to make sure that we get one of our viewer questions in, and this is from Kevin S. And Morgietta, this is for you. Why is it that the officers are not wearing their uniforms in court?
So there are many schools of thoughts on this. I've tried many cases where they actually wear it because it gives more authority to their speech and things of that nature. But I think in this particular case, it's probably to create less bias, or more bias, I should say, to their testimony, or less bias if they're an officer. And would you believe somebody in uniform more if they're not in uniform? So I think it kind of goes to that theory.
Wow. Okay.
Thank you very much.
Thank you both.
When we come back, a look ahead at what we can expect next week. Stay with us. You're watching Canton Confidential, the Karen Reed murder trial. Today, we wrapped up the 7th week of testimony, and we're starting to get a better idea of when this trial might reach the finish line.
Let's take a look at next week's schedule. Right now, we know Monday will be a full day of testimony. Tuesday, the jury will not be in court, but there will be proceedings Wednesday, court will not be in session because it's a holiday. Thursday is expected to be another full day, followed by a half day on Friday. According to the defense team, we could see the prosecution rest sometime next week.
And if that's the case, JC, and court proceedings stay on track, we could see Karen Read's fate put in the hands of the jury by the end of this month.
We also want to note, we often hear a lot outside of court from the defense, and remember, that is because the prosecution does not openly speak about the trial, so it's hard to get their perspective in real time. And we also want to leave you with this reminder of the victim in all of this, John O'Keefe. The 46-year-old served Massachusetts as a veteran of the Boston Police Department, a loving son, friend, guardian for his niece and nephew. He was killed January 29th of 2022. And of course, the lives of the family and friends and loved ones were changed forever.
Testimony resumes Monday morning. We'll see you back here Monday night at 7.